matter of SkyKick UK Ltd and another against Sky Ltd and others.
Lord Kitchen will provide a summary of the judgment in this case.
This case is about registered trademarks, and in particular applications to register marks for goods or services which the applicant has no intention to sell or supply. Trademarks are badges of origin, and the registration of a mark in respect of particular goods or services confers rights which its owner may use to discourage or prevent a rival from using the same or a similar mark in relation to the same or similar goods or services. Some registered marks aren't used for a time, or not used for all of the goods or services for which they're registered. It is therefore a feature of trademark systems that a registered mark is liable to be revoked in respect of some or all of these goods and services if there has been a continuous period of 5 years after the completion of the registration procedure in which the mark has not been put to genuine use and there are no proper reasons for that non-use. This framework gives the owner a grace period of 5 years in which to start to use it. This is important for an applicant which intends to use the mark but needs or would prefer the security of a registration before starting to do so, or needs a reasonable amount of time to develop its trade or business. But sometimes an applicant has no intention to use the mark in relation to the goods or services for which it applies, but does intend to use the registration to deter other traders from using the same or a similar mark in relation to goods or services which are the same as or very similar to those covered by the registration. This is altogether different, and the first group of issues on this appeal concerns conduct of this kind and whether it may render the registration of a mark wholly or partially invalid on the basis that the application was made in bad faith within the meaning of the relevant legislation. This question is an important one for traders and also those responsible for the various trademark registers. The Controller General, the intervener in this appeal, holds such a position. The appeal also gives rise to a number of related questions. One is whether it is permissible to infer from the size and nature of the list of goods and services for which registration is sought, and all the other circumstances, that the application was made in bad faith in respect of some or all of them. The applicant may provide an explanation and rationale which may rebut any inference of bad faith, but a further question in this appeal is whether, if it fails to do so, it is permissible to find that the registration is wholly or partially invalid because the application was made in bad faith. Another question is whether the same or a different approach should be adopted in relation to an applicant which uses broad general terms to describe and encompass what are distinct categories or subcategories of goods and services, and whether an application may be made in bad faith in respect of some, but not all of these categories or subcategories. If the answer to either of these questions is yes, this court has been asked to give guidance as to the circumstances in which bad faith may be inferred and the consequences of any such finding. There are other issues which also arise in this appeal. The first of these concerns the overarching requirement of fairness and the steps that must be taken to make sure that any decision on a matter of this kind is only made after each side has had an appropriate opportunity to address the case against it, and that the decision maker takes proper account of all of these responses. Another concerns the approach to be adopted to allegations of infringement of registered trademarks in cases such as this. There are also issues before this court, although not the courts below, arising from the decision by the United Kingdom to leave the European Union and the terms of the withdrawal agreement. In particular, a question arises as to whether this court retains jurisdiction to make any order in relation to any EU trademark in issue in proceedings which had begun but had not been decided before the end of the transition period on what is known as IP completion day. Any one or more of these issues might have justified an appeal to this court. As it is, this appeal gives rise to them all. The proceedings themselves have occupied 4 hearings and judgments of the High Court, a decision of the Court of Justice of the European Union, and a full appeal to and judgment of the Court of Appeal. It is not possible in the context of an oral summary of this kind to address each of them in detail. It is necessary instead to focus on the findings made by these courts and the conclusions this court has reached on the issues raised by this further appeal. The High Court found that the Sky marks had been applied for in bad faith because the specifications included goods and services, categories of goods and services, which Sky had never intended to sell or supply, and that Sky had sought and secured this protection regardless of whether it was commercially justified. This rendered the registrations partially invalid. The High Court also found that SkyKick's use of the mark SkyKick and variations of it in relation to their email migration product and service called Cloud Migration and their cloud storage product and service called Cloud Backup did infringe the Sky marks so far as the challenge to the validity of the registrations had failed. Both sides appealed to the Court of Appeal. Sky's appeal in relation to bad faith succeeded, and so, given the breadth of the specifications, SkyKick's cross-appeal necessarily failed. Had Sky's appeal failed, the Court of Appeal would have allowed SkyKick's appeal against the finding of infringement by Cloud Migration, but not in respect of the finding of infringement by Cloud Backup. On this further appeal, this court decides unanimously that SkyKick's appeal must be allowed in part. The court explains the circumstances which may amount to bad faith and how an application for a declaration that the registration is invalid on this ground is to be assessed. These circumstances include seeking broad protection, regardless of whether it is commercially justified, and with the intention of obtaining an exclusive right, not to use the mark in relation to the goods or for the services for which the mark is then registered, but as a legal weapon against third parties. On the findings made by the judge in the High Court, that was the case here. The Court of Appeal was therefore wrong to reverse the decision reached by the High Court on this issue. Further, the procedure adopted by a court must, of course, be fair, and each side must have a reasonable opportunity to understand and address the case made against it. But that does not mean that it is always necessary for the party claiming an application was made in bad faith to specify in advance the narrower specification, if any, to which the proprietor may have been entitled. The High Court approached the matter fairly, and here again, the Court of Appeal was wrong to interfere with the conclusion to which the High Court had come. Turning to infringement, this court is satisfied it would not be appropriate to interfere with the concurrent findings of infringement by Cloud Backup. However, the Court of Appeal was right to reverse the High Court in relation to Cloud Migration on the assumption that bad faith had been established. Where a specification of services is defined by terms which are ambiguous or not clear, it should be confined to those goods and services which are clearly covered. Here the Court of Appeal made no error in the way it approached the issue, and in the light of the case advanced, was also entitled to find that infringement had not been established. The next issue concerns the expiry of the transition period on IP completion day. This court finds that on the correct interpretation of the withdrawal agreement, the provisions of the EU trademark regulation regarding jurisdiction are and remain directly applicable in the United Kingdom in respect of legal proceedings instituted before a designated EU trademark court before the end of the transition period. Further, the provisions of the UK trademark legislation as amended make clear that as regards proceedings pending before a designated EU trademark court in the UK on IP completion day, the court seized of the dispute remains an EU trademark court thereafter. Finally, it is appropriate to mention another matter which arose at a late stage. This court was notified at a time when the judgment was being finalised that the parties had settled their dispute. SkyKick, supported by Sky, sought permission to withdraw the appeal and asked this court not to give judgment. The Controller General, on the other hand, as intervener, asked this court to proceed to give judgment in the usual way. The Court has given very careful consideration to all of the observations made by the parties and the intervener, and for the reasons set out in the judgment, decided that it was appropriate to proceed. The parties and the intervener were notified accordingly.